Okay, hello everyone. Welcome to today's program, Civility and ADR, Strengthening Advocacy Through Professionalism. I'm Ala Policastro, Director of Education and Professional Development at Beverly Hills Bar Association. And now I'm delighted to introduce our speakers. Judge Nancy Stock, Judge Stuart Rice, Edith Matthai, and moderating the program is Gina Miller. I'm now going to hand it over to Gina Miller to provide introductions for our distinguished panel.
Thank you so much for having us, Beverly Hills Bar Association. We are honored to be able to speak to you today about a topic that's very near and dear to me, which is civility. As mentioned, I have three very distinguished panel members from the GEMS organization joining us today who will give a brief introduction. And we will start with Judge Nancy Wieben Stock.
Well, good morning, everyone, and it's a privilege to be here. I'm Judge Nancy Stock. I served as a judge on the Orange County Superior Court for 24 years. I'm a neutral at JAMS, going into my 13th year, which is hard to believe. In my 24 years as a judge, I served in almost every assignment, including spending my last 5 years in our complex civil department. Along the way, I also spent 3 years as the court's presiding judge. As a neutral, my specialties are construction litigation and family law. Don't ask me what the common thread is. Maybe it's because in family law, the parties feel that they've been hammered and the foundation of their life is crumbling. But our job as neutrals is to guide them through this difficult stage. Thank you for having me.
Thank you, Judge. Now we'll hear from Edith Matthai.
I'm Edith Matthai, as said. I, at some point, started being introduced as seasoned, which I think is a euphemism. I practiced law for many years, first with my husband and Wieben Matthai, and then after he passed, I continued the firm. For over 40 years, my practice centered on the representation of attorneys in malpractice actions and other matters, fee disputes, etc. And happily, about 3 years ago, I became a neutral at JAMS. It was a tough decision to make, but I must say it was the best decision I could have made at this point in my life. I loved practicing law. I love trial work. I did a lot of trials. But there is nothing as satisfying as bringing a matter to resolution and enabling people to move on with their lives. My specialty remains both malpractice cases, and I call it all things lawyer related, fee disputes, fee splits among plaintiffs' counsel, law firm divorces, and also general business litigation. And it has been, I'm very happy and very honored to be here to have a chance to speak on something that I believe in deeply, which is lawyers do so much better when they're civil.
Thank you. Last but certainly not least, Judge Rice.
Thank you, Gina, and thank you to the Beverly Hills Bar Association for having us this morning. It's an honor to be with the other panelists and to have a chance to talk to you. I too feel very strongly about civility. I'm a member of the statewide Commission on Civility in the Legal Profession, made up of many judges and lawyers, putting together some recommendations and ideas for the future to enhance civility. The State Bar, as you know, added a civility requirement as part of their MCLE requirements, a specialized credit, and we're happy to provide that to you today. My background is had my own law firm for a long time. I was a civil litigator, went on the bench as a commissioner in 2003 and a judge in 2005, retired not quite a year ago, and have been with JAMS since then. It was very difficult to leave the bench. My last 4 years was spent in the complex courts. May have met many of you there, or in my IC court, both in Mosque and before that in Torrance. Leaving the bench was made easier by the ability to transition into this world of being a neutral with JAMS. and the opportunity to continue to work with all the fine lawyers in our community. As far as what I'm doing at JAMS, I hope I don't offend anybody by saying this, but I told JAMS I'd be willing to do anything except lemon law. So that's the only thing I excluded. I have a very varied background in civil law, and by having sat in the complex courts, the Pacific Palisade fire cases were assigned to me, all the ovarian cancer cases against J&J in the state of California were assigned to me. So I really have a desire to continue to work on complex cases. One of your handouts is an article I wrote for the Daily Journal about complex mediations, and the opportunity to work with everyone in this field has been very rewarding and made the transition that much easier.
Thank you, Judge. Before we get into the program, again, I am Gina, Senior Vice President of Operations at JAMS, and I also oversee our National Client Experience Initiatives. I, too, am very passionate about ADR. I've been with the organization for many, many years. So I'll say it that way. And resolving disputes is so important to me. And again, I just so much appreciate the opportunity to present this topic to you. So let's get into the program where Judge Rice, I'd like for you, if you can, to talk a little bit about civility, signal, strength, and ADR. What comments do you have about just that overall statement?
Yes, I think, Gina, that's really our overall theme for today. So I'll just touch on it very briefly. There's this perception among some that civility interferes with the requirement. Your number one duty as a lawyer is to be a zealous advocate for your client. And our premise is that civility actually enhances that obligation, that first obligation to be a zealous advocate for your clients. As you know, the oath to become an attorney was amended in, I think, 2014. It now includes an obligation to conduct yourself with courtesy, dignity, and integrity. The word civility itself is not mentioned in the oath, partially because civility is a little bit amorphous as to how it can be defined. But we all believe very strongly that civility does not in any way interfere with your duty to be a zealous advocate for your client and actually makes it better. And here in the ADR world, I have found that there's less formality. I call everybody by their first names. There seems to be a much more enhanced ability to collaborate and to save the bullets for the issues that really matter. Whether it's arbitration or mediation, I try to foster an environment where everybody feels that they can work collaboratively with each other to work toward a resolution of the case in a mediation, or working toward setting the matter for hearing on an arbitration, while remaining civil and respectful to one another throughout. We also can call that professionalism. All of these things enhance our job satisfaction, our joy in the profession of the practice of law, and the difficulties that come with a lack of civility. We'll address those as we proceed with this morning's program. That would be what I think we all agree on, that civility signals strength in both ADR and in litigation.
Thank you, Judge. So here's a statement: civility as a strategic advantage in mediation and arbitration. Judge Wieben Stock, is civility being misunderstood?
I think so. Judge Rice signaled one of two themes that we're going to cover today as part of our discussion. The first one is that civility signals strength in ADR. And our second theme is that civility is a strategic advantage. Civility is not just being good and kind. Civility produces a strategic advantage. And we've all heard that expression, nice guys finish last. Well, this panel doesn't think so. Now think about it. If you've paused litigation activities and are on a path to mediation, you've already chosen to take the path of civility. This is a good sign. We all know that the most effective method or path to resolution is settlement. Most of the time, settlement is in your client's best interest. By choosing civility, you've taken an important step toward client satisfaction, and isn't that what we all want? So those are our two themes as we kick off our program this morning. Gina?
Thank you. Thank you, Judge. Okay, the first question, the role of civility before mediation and arbitration starts. Edith, can you talk about that?
Yes, I think there's several ways the absence of civility can impact the ability to have an effective mediation. One of the things that happens is if counsel are simply fighting with each other for the sake of proving that they're tougher than the other guy, several things are happening. They are not giving a calm and rational evaluation of the case, which is one of your obligations to the client, is to not be embroiled, but to be able to look objectively at your case. And you want to be forceful, and I'm not saying you don't want to be strong on your case. I'm simply saying that you don't need to scream and yell about it in order to be strong. So one of the problems is we all know that the lack of civility drives up expense. And sunk cost is always an issue for clients when they've spent a tremendous amount of money already before getting to the mediation, which causes problems. So the lack of civility has started to create an expense problem before you get to the mediation. The other problem is that if you're engaged in, frankly, wasting time in fighting over things that really are not worth fighting over, you get to a mediation and then it becomes a personal issue of whether you're going to quote unquote back down after you may have taken positions that really don't make a lot of sense before the mediation, but you've taken those positions in the height of a battle with the other side. The other thing that can happen before mediation is a lawyer who becomes embroiled and insists on fighting as opposed to rationally evaluating and handling a case can drag their client into a set of emotions that are not helpful in mediation. The client needs to be able to have a calm evaluation of what their likelihood is for the outcome of the mediation, not a belief that they just simply have to fight for the sake of fighting.
Thank you. Thank you for that. Judge Wieben Stock, what do neutrals see that lawyers don't?
Gina, can I weigh in on?
Sure, absolutely, absolutely.
Yes, we're all going to participate. Each of us takes the lead on a question, but we've all met together and involved. I want to just expand upon what Edith said. As somebody who came from the bench and is now in this world, I had to adjust to the fact that in an IC court or in complex court, I had the case from the very beginning. And when you have the case from the very beginning, you meet the lawyers at that initial conference, you try to set a tone, you let them know your guidelines, and if you see problems beginning to emerge, you can attempt to address them. So get everybody back on a proper course, keep the acrimony down whenever you're able. In this world of ADR, whether it's a mediation or an arbitration, we are not getting the case from the beginning. And I think when we do these pre-meetings on mediation, it's very helpful. It's been very helpful to me to get a sense of what is going on in the relationships between the lawyers, between the client. Sometimes there's an issue between client and attorney as well. It's very helpful to know that. And so that when we, as Edith said, we enter the fray and people are already angry with one another, if for me and Judge Stock as former judges, we knew what was coming when we got to that stage of a case, whether it was trial as compared to arbitration, or if we were helping the parties to settle a case. So just when Edith made that comment, I thought it was important to point out that, whoa, where's this energy coming from when we have met the people for the very first time?
Well, and I think that is one of the things that I think lawyers sometimes forget is that as a neutral, I'm not engaged in your emotions. I'm trying to look at the case from a very, very rational perspective. I need to understand those emotions so that I can appropriately address them, but I don't take them on. And sometimes you see lawyers who are bound and determined to get the neutral to engage in the fight as opposed to working with the parties to bring a matter to resolution. On the arbitration side, and I have seen it in arbitration, much to my unhappiness, is that if counsel are fighting with each other, I, I I'm not there to decide which counsel is the good guy and which counsel is the bad guy. I'm there to resolve the case. And I don't appreciate the fight at all.
So, Edith, you made a comment in your remarks. You talked about poor behavior drags the client into the emotions that the lawyer is feeling. It's almost like they've switched roles. And I think about family law. You know, the stereotype is that family law clients have their hair on fire. They're good people that are going through the worst stage of their life. And the fact of the matter is, my perception of the family law bar is that the good family law lawyers exercise leadership from the beginning and don't drag their clients any lower than the clients already are. And I like Judge Rice's comment too, that as neutrals, particularly in mediation, we can serve as partners, kind of anchor to us, and let's both exercise some leadership. Let's rise above the fray. Let's help you as attorneys neutralize the situation. It might be in your own room because your client has been dragged into the fray, or it could be in the other room. But it's all about leadership before the mediation even begins. So I love that comment by Edith.
And Judge Rice, I really appreciate you bringing up the pre-mediation conversation. In my role, that is feedback that I hear from all over the country, how important it is in the mediation setting is to having that pre-call with the neutral before the actual hearing. So thank you for making that comment. So back to Judge Wieben Stock. What do neutrals see that lawyers don't?
Well, I would open with the observation that the practice of law is not as big as you think. So, for example, the Beverly Hills Bar Association is a tight and collegial group of people that hang together for common purposes. And so are many of the specialty bars in our practice. It's not a lot of anonymity. People know where you live. You often will represent opposite sides of the same kind of thing from day to day, client to client. So when law firms develop a reputation for sharp practices, or individual attorneys have acted up in places where they don't think a judge will go, like a videotape deposition, the word spreads rapidly. In our current climate, it's not uncommon for somebody to just strategically insert your worst conduct into a video or audio clip, and it goes right to the neutral. Nothing is worse than becoming the topic of conversation over lunch in the judge's cafeteria, and there's a version of that in the private world as well. We may see things that you don't, like the pained look on your client's face when the proceedings have taken over with needless squabbling. We are laser-like riveted to your client. We are rising above it, and you may be missing the boat. Since our job as neutrals is to facilitate a fair playing field during mediation, we can feel the energy leave the room when our efforts are being expended and wasted, trying to bring the conversation back to the client's best interest. Don't be the attorney that's causing that energy to leave your room. For this reason, I think it's best to work in partnership with your mediator. As I mentioned, there's lots of ways to do that. Pre-conferencing, committing to jointly helping the client, because we want to take the direction and work together to bring that dialogue into alignment with your client's goals for settlement. At the end of the day, that's what the client wants, and incivility doesn't get us there. It can impede the progress.
Edith, Judge Rice, anything else to add to that?
Yeah, I'd like to follow up on Judge Stock's comment about the reputation. Lawyers do get a reputation quite quickly, actually. And for a huge town, city, the legal profession is actually very small in the areas in which people tend to specialize. And people remember. And one of the things that I tell very young lawyers is that when I came out of law school and started practicing, in my wildest dreams, did I think I would still have contacts and relationships with people that I met in my first 5 years of practice. And you build a reputation and you build friendships and relationships that last for years and years and years. And you want those relationships to be good and you want your reputation to be good.
Thank you. Okay. Judge Rice, how does civility impact professional reputations?
Well, as with most of the questions that we put together for today's panel, one leads to the other. So Judge Stock's comments and Edith's follow-up leads very nicely into how it affects your reputations. As Edith was talking, I thought of a couple things. Personal anecdote that I did meet my wife as my opposing counsel. So there you go. So civility, we're still together. And years ago, when I was a young lawyer, I was on the Jenny Commission. For any of you who are interested in applying to become a judge. Even if you're not, what an eye-opener that was. Because we would send out questionnaires. Now it's all done uh, online, so it's easier to fill out. As judges, we get one for every applicant. If we don't know them, we don't fill it out. And you get all these forms back. And when 15 different people say that I had a case against so-and-so and they didn't return my calls, they were rude when we were together, you're going to be ranked not qualified. So not only within the community, but also if you aspire, it could follow you. Your reputation is really the most important thing you have to preserve. And for those of us that are, involved in bar associations, LA County Bar, Beverly Hills Bar, ABOTA, other groups, I always tried to attend. I was very active as a lawyer and tried to always attend as a judge as well. And then you see those two of the people that you were talking to at a bar event as opposing counsel in your courtroom, they tend to get along better because they know one another. As Edith said, they may have met a long time ago and they've always maintained a professional respect for one another. It just makes the practice of law that much better. When I'm doing a mediation, for example, we expect some puffery. I mean, that's not uncivil. It's not uncivil to ask for an amount of money that is much more than the case is worth or to offer much less. That's just part of negotiation. And we as neutrals have to recognize that difference as well. But when one side or the other starts making personal attacks against the other attorney, it's not productive. And especially when made in front of the client, there's a variety of ways in which that plays out. Also, sometimes you're communicating to us as the neutral to bring that message to the other side. And so that information should be accurate. Don't tell us something that is just wrong or can be easily contradicted. That plays into your success. It plays into what we are describing broadly as a lack of civility, and it impacts your reputation. If I'm lied to, if I was lied to on the bench, now we're seeing it in the AI arena where lawyers are being disciplined for citing the cases that don't exist because they used AI and without checking it. All of that matters in terms of your integrity and impacts your reputation. I do want to also reference this case that I put in the materials that in the handout. It's the Martinez case. And you just wonder, what was this lawyer thinking? This lawyer was appealing a ruling from a woman judge, and in the appeal, in the brief to the Court of Appeal, referred to the judge as succubistic. What did that lawyer accomplish? That he knew a big word? I had to look it up when I first read the case. It's an ancient word which refers to a demon, usually taking female form. What did he think was going to happen by attacking the trial judge, not by saying her ruling was wrong and this is why, but by a personal attack? It makes no sense. And the Court of Appeal referred that attorney to the state bar. That's an extreme example, but there it is in a published decision. And anybody that read that decision and saw who that lawyer was, that they're going to say, "Oh, that's the succubistic lawyer." So these are things that you have to bear in mind. I also was thinking when I was a lawyer and mediation was just in its infancy. A retired judge that I knew, I hired her for a mediation, and she just kept coming back to me to go down. I said, Your Honor, it's back and forth. She said, I can't even sit with that lawyer, Stu. He's so unpleasant. I said, well, so in other words, I'm supposed to go down because I'm civil and kind. It was ultimately not effective, but it did affect that neutral. And that's right after that, I went and took the class at Pepperdine on mediating the litigated case because I thought I can do a better job than this while I was still in practice doing free mediations for the court, which are more difficult because the parties aren't paying you. They don't necessarily want to be there. But even with that, I think it's essential that in that environment that we try to work collaboratively. We're there to help both sides. And
You
another
know,
thing, and one last thing I want to add is, so plaintiff usually makes the first demand. We've gone through whatever we go through. The plaintiff's demand, I say to them, that is not going to invite a reasonable response. Well, Your Honor, that's where we want to start. Okay. So then the defense would likely respond with a modest offer. But when the defense says, and there's nobody in the room except them and me, it's going to be a short day. How is that helpful? I mean, I'm not going to dismiss that lawyer as ineffective or lacks civility, therefore I'm not going to engage. But it's something that you remember. And, I said that we've been doing this a long time. Is this the first time a plaintiff has made an unreasonable demand to begin? So all of these things play a role in how you are perceived. And we all know that your credibility is essential to your effectiveness. If you lack credibility, the court's not going to listen to you. The mediator's not going to take your points as something that he or she should advocate on your behalf to the others. We go back and forth, and I like it when both attorneys are able to say, well, yes, that document exists, but this is the context in which it arose, rather than we have 10 texts in which da-da-da happened. All right, well, send them the text, and then there really aren't 10 texts that say anything like what was said. So that's ineffective. That's not just puffery. That leads to a lesser success for you. And protecting your professional reputation is everything.
that was when my thought as you were speaking, Stuart, is that the reputation for honesty is huge for a lawyer. You can be so much more effective if when you say something, the other side believes you. Because if you're a known liar, then they simply disregard everything you say, whether or not it is true. So your reputation for honesty, in my view, is necessary for the effective practice of law, both during litigation activities and in mediation. No, no mediator and no arbitrator wants to be lied to. We don't react well to it. So I do suggest avoiding it.
And wouldn't you say, Edith, that honesty is under the umbrella of civility?
Absolutely.
And professionalism.
Yeah, these are the guideposts for us while never losing sight of that obligation to be a zealous advocate.
And Edith
You
raises a
can,
good point. There's really two audiences at all times. It's not just the mediator or the private judge, it's the opposing counsel. And being believed by opposing counsel may be even more important. I like that point.
Well, this is a good time for the next question, Edith, that I'll direct to you. As it relates to the attorney's client, how does civility impact clients?
Well, I think it sets a tone with the client for the handling of the litigation. And as I mentioned a little earlier, one of the things that can happen with a lawyer who believes that the way to practice is to be nasty, arrogant, and otherwise unlikable is that they can drag their client into the same mode, which doesn't accomplish anything except to raise everyone's emotions. And when the emotions are high, decisions get made that are not the best decision because it just impacts your whole view. And so if the lawyer brings the client into the fray, it can create all kinds of problems. And also, it can create the problem of, we all know, as I said earlier, driving up of the expense by engaging in needless fights, which just don't do any good and drive up the cost. One of the in Stuart's compilation of cases that address civility, which is in your program, and it's a great compilation of these cases because the courts are not happy with lawyers who behave badly. But one of the quotes that I have always loved is from the Carton case, which is in your materials. And it says, all of these human hours, which could have been put to socially productive uses, instead are devoted to the unnecessary war and are lost forever. All sides lose, as does the justice system, which must supervise the hostilities. I've always loved that quote because it says it all. What are you doing wasting all of that time and spending your client's money on a fight that is not going to advance the litigation? If and there are ways you have to be directed and firm. I'm not saying to not do that. If there's a document you need and it hasn't been produced, then you're persistent and you say, I need to get that, I need to get that, I need to get that. But you're not nasty about it, and you don't drive up the cost by, engaging in unnecessary practice. You don't drive up the cost for the clients by going on fishing expeditions that are never really going to advance the case. And again, most importantly, if the client, the incivility of the lawyer can affect the client's ability to rationally evaluate their case by embroiling the client in the warfare. But there's another side of it too, which is sometimes it is indeed the client is so angry about whatever occurred that the client is not exercising good judgment and the client is driving an incivility, sometimes even with their own lawyer. That certainly does happen. But the job of the lawyer, in my opinion, in that circumstance, is to remain ever calm with their clients and ever civil with their clients and explain to their clients the benefit of handling the case in a manner that is straightforward and direct and doesn't involve screaming at people.
so I'd like to add something as well. I mean, I agree with everything Edith said. The question, because it's about the clients, more in the context of mediation than when I was a judge hearing trials or now arbitrations. I think in a mediation sometimes we have to let the client talk and vent, and they may say things that aren't that civil. Now, there's a line where even with the client, I may say, well, let's try to not make it so personal, but sometimes it is personal. And we need to know that if the cases we're struggling being able to help you settle the case because the client just can't get past a certain emotional betrayal Often there's betrayal or there had been a trusting relationship which has been broken. And that's why these pre-meets are helpful as well. I always want to know, how do you want to handle your client? Do you want your client to have time just to talk to me? And so the lawyer should always be civil, and they shouldn't advise their clients to be civil. But I give a little more leeway when that opportunity to be heard, because they're not going to go to trial, they're going to be heard in the mediation, helps them to get something off their chest in a way that will enable more reasonableness going forward. And I always ask the lawyers in the pre-meet how they feel that would best be handled.
So something Edith said makes me believe that there is a business case to be made for attorney civility. Unnecessarily inflaming your client's emotions place you at risk of them not being able to sign a deal at the end of the day. We've all been in that situation where an attorney will report that the client is too distraught. We have all the deal points in place, but the client is too distraught to actually sit down and go through it and sign the deal that day. Or if the client does sign the deal, you're at risk that there's buyer's remorse. The client wasn't possessed of all her faculties at the time, has doubts, was not clear about things because she was so distraught and emotionally overwhelmed in trying to make a business decision. And so that buyer's remorse is not good for business. It's not a good place for you to be. And it reminds me a little bit of Edith's former practice. So there's a business case to be made for not excessively inflaming the client, putting the client in a position where the most important decision they're going to be making that day can't be made.
Well, and I'd like to echo that and echo what Stuart said about letting clients vet during a mediation process. And I agree that it's extremely important for the mediator to find out in that pre-mediation call something about the client and how they're likely to react in the mediation. And whether or not that's a client who does need to vent, which can be done without inflaming the client, but letting them have full say and give all of the reasons why they believe they have been impacted by whatever has occurred. And some of those, listening to some of those stories, frankly, it's heartbreaking. You're hearing somebody pour out their emotions about what has happened to them, and that's fine. That's not incivility. That is real life. And there's a difference between allowing the client to fully explore those emotions and how it's impacted their belief about what they should recover in the litigation, and then guiding them in the appropriate way with their counsel about what they can accomplish in a litigation and what they can't accomplish in the litigation. One of the things that's so true with so many of the clients that are so emotional is they think somehow they're going to truly get paid for that as a result of the case. It doesn't really work that way. Because as we all know, by the time you get to the end, you may not recover what you think you should, and what you do recover is going to be severely impacted by all of the expense of getting to the end. And the longer you litigate, the higher that expense is. So letting a client explore all that, even letting them explore the fact that that very reality that when they get to the end, they may not be able to feel that they have been made whole, is something that they should be able to freely express, discuss, and then get to a point where they recognize that the best course of action is to get something reasonable to resolve the case.
Thank you. I just wanted to remind the audience that we do have a Q&A box. If you have questions, we're happy to take questions during the presentation or even at the end. So we definitely welcome some questions as we near the end. It's been several years since, to say the word, the pandemic. And our profession has proven that we can conduct business in a different way. We're advancing, we're innovating, we're enhancing how we do business. So, Judge Wieben Stock, how does the current virtual era impact civility?
Well, we are now, hard to believe, 6 years into the sea change that occurred when, in the wake of the COVID-related shutdowns, arbitrations and mediations were converted to a virtual platform such as Zoom. Now, in the beginning, I think we all worried, lawyers and neutrals alike, that context would be lost, clients would not feel heard, and the virtual environment would only exacerbate bad attorney conduct. Now, did those things happen? Yes, I think anecdotally it happened. But in my opinion, for the most part, the virtual environment has served to bring greater inclusion and more access to the proceedings from folks who may not have been able to travel, for example, to the hearing. So we're also now seeing a movement toward voice-to-voice resolution of disputes. I think some of the outcomes have led courts and others to realize that we need to get in the room. I think the courts are requiring it. And I know I require it in my private arbitration practice. It's not a meet and confer when associates are zinging emails back and forth with no intention of ever discussing the matter. And it's always a good step when the handling attorneys are the ones talking. So one thought about civility as it relates to the virtual environment. You and your client nowadays are going to always be on camera. And in some cases, the mic is hot, not in a good way. In the old days, I sat as a trial judge. I sat in a number of different kinds of courtrooms. Some of them were shoeboxes, and I finished my career in a formal federal courtroom that was as big as my first condominium. And so my sight lines and my focus on evidence taking was different. When a witness was testifying, usually the judge's attention was riveted to the witness stand. You'd be looking kind of to the side, maybe on top of somebody's head, and paying attention to that witness. The attorney and the client were out of the judge's sight line. With Zoom, a judge can now look anywhere in the virtual courtroom, has the ability to spotlight, and can just be plain curious about what's going on while that witness is testifying. In this environment, we catch snickering, eye-rolling conduct, both the clients, the attorneys, that ultimately affect that person's credibility. So if anything, migration to the virtual platform has opened up new avenues for the unfortunate display of civility, and many of us have had to take classes on how to properly conduct yourself in this particular environment. Another aspect of this discussion that I'd love to hear from folks about is the generational shift to younger folks who may have thrived on screens and devices and still do, and have a different skill set relative to face and what we all used to think is the old-fashioned, you get in your car, you drive to court, and you stand at the podium. So there may be some cultural differences in generational thought processes in how we relate to each other and how we conduct ourselves. So that's a whole interesting issue as well.
I think that's a really important issue because at some point in my practice with younger associates, I would ask them whether they had gotten something from the other side. And the answer I would get is, well, I sent them an email. I said, well, do you have it? No, I sent them an email. Okay. Well, did you talk to them? No. And there seems to be in this world of emails and texting, there seems to be an absence of direct communication by voice. And I really deplore that because if you can have a conversation with your opposing counsel that is civil and to the point and gets things done, it is so much more helpful. That email can be misinterpreted, and that's when you get the fire back, which starts the escalation of hostilities. And by the way, if you get an email where you want to fire back, stop, calm down, then send a very calm email in response. But pick up the phone, talk. One of the problems with email and text communications is that it's typically single subject. If you are on the phone with your opposing counsel and you call because you want to, set a deposition or meet and confer on a joint statement or something of that issue, now you can go beyond the issues and you can start talking about the case with each other, which is generally a very good thing because if you're civil and polite with each other, you can work out a whole lot of things easily rather than getting into the kinds of arguments that escalate costs. So my comment is please pick up the phone and talk to your opposing counsel, or even better yet, ask them for a cup of coffee. Sit down with them, talk about the issues in the case, and see what can be worked out and see what can be done to have a rational discovery plan, to have a rational approach to litigation, and just do business.
In our pre-meet, we discussed the pluses and minuses of the access to justice through remote proceedings, etc. And it is a two-edged sword. And I agree with all the comments made. It reminds me, I had a case, hundreds of millions of dollars in complex. These two lawyers had worked with each other, opposing each other for a long time. They had an IDC with me. And then there was a motion, and I was very surprised. And when they walked into my courtroom, didn't appear remotely. And I believe strongly if you're going to win or lose something, you should be in person. I think you're your best advocate when you are in person. And I agree with Judge Stock. I try to do all my arbitrations live. You can have remote witnesses if that happens. So anyway, when the lawyers came in the room, I said, Counsel, I have to say I'm a little surprised to see you here after our earlier meeting and the fact that the relationship we have with one another and your sophistication in this subject area. Your Honor, don't mean to interrupt you. We got here early. We had coffee. It's resolved. We'll have an order to you by the end of the day. That wouldn't have happened, right, Edith, if there was just an exchange of emails. The communication is just so much better. On the other hand, I did 3 trials in a row for these 2 very wealthy real estate investors who had trusted one another, shared all their money, and then they had a falling out. And the first 2 trials in the courtroom, they would scream at each other from the witness stand or from the audience. But the 3rd trial was done remotely, and they behaved. So something about that barrier actually, in that instance, nobody was yelling at each other when the other one was trying to testify. But I think this is the world in which we live now, and the communication can breed incivility, right? The lack of communication, no response to an email. Oh, I was busy. I overlooked it. As opposed to a phone call. Even with phone calls, though, now, Edith, I think you call when somebody wouldn't show up for a hearing, we'd call their office and it goes right into voicemail. There's no live reception. So, I mean, technology has also makes it often less personal. So, it's an important issue, and I think it folds very nicely into this overall topic. And I'm glad, Gina, that you came up with this as a question for us to address.
I appreciate that. So the next question is actually my favorite question. I'm going to direct it to all of you. Edith, we're going to start with you. And I always learn every single time we have programs like this. How do you deal with counsel who are not civil?
Well, this is a subject that is near and dear to my heart. And my first simplistic response is don't bite. Don't react to it. A bully wants you to do what the bully wants you to do. And if you react to the bully, then what's going to happen is that fight is going to escalate, and you have given them the power over you to make you react. Well, I'm pretty stubborn. I'm not going to give somebody on the other side of the case the power to make me react. Now, not reacting to somebody who's bullying you or yelling at you or wanting you to do something you don't want to do is sometimes very hard because your instant reaction is you do want to slam back. But if you take a pause and you think about the benefits of not slamming back, you won't. There's also a tip that I got when I was a very, very young lawyer at a seminar in Hawaii where everything's mellow. And there was a speaker there who was a psychologist. It was a very small group. And the question that was asked of him was, what do you do when you have to deal with a jerk? And he said, well, you put yourself in situations where you don't have to deal with a jerk. And the lawyer looked at him and said, no, 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 you don't understand. You just don't understand. In my world, you got to deal with jerks. And his response was very interesting and very helpful. And I've remembered it for all of these years. What he said was, you react because you go into this encounter believing and expecting this person not to be a jerk. But if in fact they are a jerk, and you know they're a jerk, and you accept the fact that they're a jerk, then when they are a jerk, it's just doing what you expected them to do, and it doesn't bother you nearly as much. And that is very true. The other thing about bullies is they want you to respond. And when you don't respond with antagonism, they don't quite know what to do because they want to fight. They want to fight with you. And if they want you to do something, you say, no, I'm not going to do that. And they keep yelling and you say, no, no, I'm not going to do that. And they keep yelling and you say, no, no, I think I mentioned I'm not going to do that. And then they have no plan B. If they don't get what they want by bullying you, most of these people really don't know how to move into a logical, persuasive conversation, which would have gotten perhaps the result they wanted instead of screaming. The other problem with incivility is, while I absolutely deplore the idea of acting back and getting into the battle, I will also tell you that I have always felt that an incivil lawyer on the other side of one of my cases was always very, very inspiring. When I went to a very first trial many, many, many years ago and um, came to court that first morning, and my opposing counsel looked at me and said, and I quote, if you knew what you were doing, little girl, you wouldn't be here.
Oh, no.
And I said, well, okay, we're going to pick a jury. And I will tell you that I would have worked 27 hours a day to make sure that I won that case because I was going to make sure that he understood that I did belong there. So, one of the things I say about the reasons not to be a jerk is, why do you want to be that inspiring to your opposing counsel? It's just not a good idea.
I like Edith's formula here. It reminds me of a formula for self-care. Self-preservation and lasting in the industry is important to all of us. And she said something about don't cede your power in this embroilment with this bully. And it reminds me of the expression that it's easier to sing and dance when you're not carrying the piano. Don't carry this stuff. And that leads to the idea of how do we pass this message along, firm culture, mentoring, what messaging are we giving our younger attorneys when they, of course, are faced with little girl and all sorts of other different things. I just think it's so important to be thinking about how we're training and mentoring our young lawyers. And for the young lawyers in the group, maybe thinking about what firm you want to be in or not be in for that very reason. Your first 5 years are awfully important to learn how to not carry the piano, don't cede the power, have it motivate you like nothing else to be the best advocate you can. And I hope that leadership starts from the top. I hope that's the culture in the firms that you're in.
Judge Rice, any follow-up to that? Thank you.
I think everything's been covered, and I think the next subject flows very nicely from this, which I believe is going to me.
It's going to you. Thank you. So, what are the economics of civility for attorneys and their clients?
So this is also a subject that we all discussed and encourage everybody to weigh in. I think the hour that's starting to wrap up, the theme is civility is good for you in all ways. Helps your success, your reputation, and also your bottom line. If you read some of these cases that I put in the compendium, there's a number of cases in which there was a motion for attorney's fees, which went up on appeal. I asked for 450,000, I got 80. And the Court of Appeals reaction is, well, you're lucky you got 80 because you, from reading the record, you through your lack of civility, caused this case to be far more expensive than it needed to be. Or the denial of attorney's fees altogether. The courts of appeal have become much more emboldened on the issues of civility, and it can really make a difference in your own bottom line, your reputation, your future in the profession. And also, civility, doing your best to get along without ceding your power. That's why we put that topic in there, because it's very important. I tried to pay close attention to that as a judge when somebody was being bullied and brought a motion because they had no other choice to recognize that. But through working together, we save stress, we save time, we save money in how that litigation can be resolved. I've been very heartened here in this new arena that I'm in. I always did IDCs as a judge, probably did a couple hundred of them, maybe had 10 motions. And I've let everybody know that I'm going to do them in this environment as well. I had an IDC the other day. I didn't ask for this, but they sent me a 12-page memo where they both very skillfully advocated for their respective positions on 4 distinct issues on a big case with good issues involving there were issues of privilege and other issues that we would expect sometimes that you can't agree on. And we held a meeting, and in 45 minutes, all 4 issues were resolved. They prepared an order together, which was exactly as I had asked. And that issue is now over, and they can go back to getting that discovery or agreeing that they're not going to get that. No motion, and really excellent attorneys who had a professional disagreement. Nobody had to give in, and we did that. I didn't expect this to happen so often, but I said, look, I'm not a full-time judge anymore. If you're having a dispute at a deposition and starting to getting hot and you can't resolve it, call my case manager. If I'm free, I'll talk to you from a deposition. I did that a couple times as a judge, but not that often because I just didn't have the time. But I've now done it twice, and boy, you could feel through the screen, you could feel the heightened sense of emotion and that the other side was being unreasonable. But even then, they chose to call rather than recess the deposition, spending more time and money, or getting angry with one another. And again, they through by making the choice to utilize a third person, we were able to resolve those issues through compromise. So the best lawyers will turn to some avenue to see if we can resolve our dispute without the necessity of it becoming personal, unnecessarily expensive, and potentially damaging to your own reputation. So I think when you sum up everything that we've done, really, we don't want to lose sight of the economics. We are a profession, but you do want to be making a good living with a good quality of life, and making sure civility is part of your everyday goals as a practicing attorney will help foster that success.
Thank you so much, Judge Rice. And just out of respect of everyone's time, we are near the top of the hour. I am available for questions or comments or just continuing the discussion after the program. I'm going to quickly just turn it over to Judge Wieben Stock, Edith Matthai, just for some final thoughts. And then we can conclude the program. And again, thank you so much, Beverly Hills Bar Association. Judge Stock.
Yes, and I think the panel is available to stick around if that's a possibility. Thank you, everybody, for your attention. I think my takeaway is real simple. I loved being an advocate. I loved being a lawyer. And I think civility leads to outstanding advocacy. And I think we've demonstrated that here today. So good luck in your practices. You will be believed, you will be persuasive, and you will have success in the settlement room if you follow these practices.
And life is so much easier when you don't add the stress of unnecessary battles.
Self-care.
Self-care.
Judge Rice.
Well, I think I was able to cover what would have been my closing comments when you turned to me on the economics, and it's 11:01, and we did it in exactly an hour without a real rehearsal.
And the materials, I believe, are in the chat box, but if for some reason you can't download that, you can contact the Beverly Hills Bar and we will make sure you get those materials. And with that, I think I'm going to turn this back over to the Beverly Hills Bar Association. But for those who have attended, just thank you so much for your time and for listening to us and sharing your interest in this very important topic in our industry.
This concludes today's presentation. Thank you so much to our panelists for joining us today and educating our members. And thank you so much to our audience. Have a great day, everybody.